Okay, if you've ever lived in a place with a homeowners association, you already know. You know that disputes can pop up over just about anything. But sometimes those little disputes blow up and become about these huge questions of responsibility, of money, and, the super fine print in documents that are decades old. So let's dive into one of those stories. It's all about a crumbling wall out in Scottsdale, Arizona. And it all comes down to this. Right here, a single sentence, highlighted on an old property map from way back in 1996. For the homeowner, Carolyn Wefsenmoe, these words seemed totally crystal clear. I mean, this was the foundation for her whole case, a promise she was sure the HOA had broken. But as you're about to see, a single sentence rarely, if ever, tells the whole story. All right, so let's meet the players. On one side, you've got Carolyn Wefsenmoe, a homeowner in a community called Summit View. And on the other side, the Summit View Homeowners Association, the HOA. And the whole fight is about this one deteriorating wall right on the edge of her property. The big question is, who's going to have to pay to get it fixed? Now here's what's so fascinating. You have two sides looking at the exact same problem, the same wall, and they come to completely opposite conclusions. Ms. Wefsenmoe's argument was simple. The HOA has to take care of all subdivision perimeter walls, period. But the HOA, they came back and said, nope, individual owners are responsible for any walls that are built on their own property. And get this, both of them were totally convinced the community's own rules back them up.
So let's break down the homeowner's argument first. For Ms. Wefsenmoe, the answer was just sitting there in black and white, written long before she even lived there, right on the community's original map. And this right here, this is the heart of her whole claim. The 1996 Plat map, that's the official document that laid out the entire neighborhood. It says clear as day that the HOA has responsibility for maintaining all common areas. And then it specifically calls out subdivision perimeter walls as being part of that. I mean, to her, this looked like a total slam dunk. Case closed.
And you can hear it in her own words from the hearing. She said, this is a covenant. She didn't see this as just some suggestion. She saw it as a binding promise. She thought that document guaranteed she wouldn't have to worry about fixing this thing, especially since the other side of the wall was on common ground.
And to back this up even more, she pointed to this little detail on the map. See that WME right there? That stands for a 5-foot wall maintenance easement. It's a strip of land set aside specifically for, well, wall maintenance. So her argument was, why on earth would that even exist if the HOA wasn't the one who was supposed to be doing the maintaining? It makes sense, right?
But of course, the HOA saw things very, very differently, so let's flip over to their side of the story. Their entire case wasn't built on that old map. No, it was built on a much newer and much more detailed set of rules.
The HOA basically argued that 1996 map, well, that was just a plan, kind of like a forecast made before a single house was even built. The real rules, the ones that everyone had to follow, they said, were laid out 8 years later in the 2004 Covenants, Conditions, and Restrictions, what everyone calls the CC&Rs. And those are way more specific. And you can really see their strategy here. They started pointing to all these specific articles in the newer CC&Rs. One says owners have to maintain everything on their own lot. Another says owners are financially on the hook for walls on their lot and even need permission to fix them. And then here's the kicker. Another article says the HOA only has to maintain the paint on the building walls, drawing a super clear line between the house itself and a perimeter wall. You know, the disagreement got so deep that they couldn't even agree on why the wall was falling apart in the first place. Ms. Wefsenmoe said it was erosion happening on the common area side of the wall, but the HOA fired back, saying the real problem was water coming from her side, probably from blocked drains or something. So they weren't just arguing about the rules, they were arguing about basic physics.
So now you've got conflicting documents, you've got conflicting stories, and a judge has to sort it all out. And believe it or not, the entire decision came down to one single, really basic question that somehow neither side had actually proven.
And here it is, the million-dollar question. Where is the wall physically located? Is it on Carolyn Wefsenmoe's private property, or is it on the HOA's common area? That's it. The answer to that one simple question would decide everything. Which documents mattered, which rules applied. The whole case was balancing on that one point. And this is where we have to talk about a really important legal idea called the burden of proof. See, in a case like this, the person who files the complaint, that's the petitioner, it's their job to prove their side of the story. She didn't have to prove it beyond a shadow of a doubt, but she did have to convince the judge that her claim was more probably true than not.
And this is where her case just completely fell apart. Because in the final ruling, the judge pointed out this one critical thing that happened during the hearing. Ms. Wefsenmoe admitted that no one had ever done a professional survey to figure out where exactly the wall was. She was just assuming it was on the common area, but she didn't have the paperwork to prove it.
And that was it. That was the fatal flaw. The judge basically said, look, without a survey, without some kind of hard evidence, there is no persuasive proof that this wall is on common land. And because of that, the petitioner, she failed to carry her burden of proof. Her entire case was built on an assumption she couldn't prove.
So just like that, the legal fight was over. But the lessons we can learn from this are honestly so important for anyone who lives in a neighborhood with an HOA. The final verdict was short and not so sweet. The judge's order: petitioner's petition is denied. She lost. The responsibility and the bill for fixing that wall was now hers. So what does this all mean for you? Well, here are the big takeaways. First, in an HOA dispute, the newest, most specific rule usually wins. The detailed CC&Rs are almost always going to beat an old map. Second, hard evidence beats a gut feeling every single time. Thinking you're right isn't enough. You've got to be able to prove it with something like a survey. Third, location, location, location. It's not just for buying a house. It can be the one fact that decides a whole legal case. And finally, and this is maybe the most important one, you've got to read your documents. It's boring, I know, but all your rights and responsibilities are sitting right there in the fine print.
And that really leaves us with one final question to think about for our own homes. Before a fight ever starts, do you know, for sure, exactly where your property line ends and the common property begins? It seems like such a simple question, but as this whole story shows, not knowing the answer can cost you big time.